right, so good afternoon, everybody. Welcome, welcome, welcome. I am Renee Hutchins-Laurent, as I say all the time, proud dean of this remarkable institution. So now in its second year, this Visiting Scholars program was established by former Maryland Carey Law Board of Visitors Chair and amazing, wonderful, incredible, longtime supporter of the business law program, Christine Edwards. She's from the class of '83. Along with other alumni and friends. And the endowment was created to honor Professor Tobin, who I think is still en route, right? Okay, to honor Professor Tobin, who completed his tenure as Dean of Maryland Carey Law in 2022, and who currently teaches in the business law program. So this year's visitor is the incredible, remarkable, dynamic Professor Veronica Root Martinez from Duke University School of Law. She's a nationally recognized scholar in corporate compliance, corporate governance, business ethics, and her work challenges us to think a little bit more critically about how organizations structure compliance systems. So not just satisfying regulators, like not just looking at that as the goal, but also genuinely preventing misconduct and strengthening an ethical culture. At Duke, Professor Root Martinez holds the Simpson, Thatcher, and Bartlett Distinguished Professorship of Law, and she holds a courtesy appointment at the Fuqua School of Business. Her teaching includes courses in ethics and professional responsibility, securities litigation, enforcement and compliance, corporate compliance and ethics, and judicial ethics. Her scholarly works have been published in a gazillion, 1,001, and 25 places, including the Harvard Law Review and the Columbia Law Review. And her book, Building an Effective Ethics and Compliance Program, is forthcoming. She is also, because she is way, way, way too productive, a co-author on the 5th edition of the casebook Securities Litigation, Enforcement, and Compliance, as well as a co-author on the 6th edition of Professional Responsibility, A Contemporary Approach. So today, Professor Root Martinez is going to talk to us a little bit about reconsidering the dominant enforcement-driven model of corporate compliance in favor of a more purpose-driven approach to the compliance framework, one that will align more with a firm's mission and risk and ethical aspirations instead of focusing just on government enforcement priorities. So please join me in thanking her and welcoming her, and then I will turn it over to Professor Root Martinez.
Well, that was quite the introduction. I really appreciate that, and I want to say thank you all for being here and for inviting me to be here. I'm very happy to be here. I had the pleasure of speaking in Professor Moon's class earlier today and had a really wonderful time engaging with students. And I said something on accident during that class because my phone rang, and I was like, oh, I have all these children, I have to turn off my phone. And so I also want to add that I am the proud parent of Abigail, who is 10, Gabriel, who is 9, Samuel, who is 6. And actually, this is going to be a little ad-lib, but this is going to matter as we go along through this presentation. Okay, so this project is called Purpose-Driven Compliance. Okay, so why does compliance matter? I am not so naive to think that you hear the word compliance and do something other than roll your eyes. Oh, good Lord. Someone's going to talk to me about compliance. I'm going to be bored out of my mind for the rest of my life. So I am working on this book project, and I spent a lot of time thinking about the preface and what example I was going to use to convince folks that what I was talking about mattered to their everyday life, wasn't boring, and I'm not going to tell you that scenario, but I am going to use a different one. And so a few years ago, I was giving one of my compliance papers at a workshop at a law school, and the law school was all a tizzy because someone had just come and done a Title IX training, and the Title IX training had obviously gone badly. And the Title IX training said that the faculty had to be, that they were mandatory reporters, and so if they learned of certain information, they were required to report. And the faculty was so upset about this, and multiple of them said to me, well, I'm not going to comply because I am going to support my students and doing all these other things. And in my head, I'm thinking, there are reasons you should comply, like tracking. You might have like a particular person who you need to know that there have been repeat complaints about. Like, so I'm sitting there being like, well, this is not really my business, but this is a classic example of what can go wrong when people don't understand why the compliance idea matters. And so compliance matters for all of us, whether it's Title IX and making sure we have appropriate tracking and recording, whether it is you think that anti-money laundering rules are really silly or whatever, but if you go back to the 90s when we think about why we got the anti-money laundering rules, which was often related to things like terrorist financing and making sure that we don't have improper money going to places we don't want it to go, then it can make more sense. But the more distance we get from those requirements, the harder it can be to understand why something is in place and why it might seem rote. So anyway, so compliance does matter to our everyday lives. And part of that is because when we're talking about compliance, we're really talking about how organizations translate their obligations. And obligations can come from a variety of sources. So to the law, to people, and to society, into daily decisions, right? So part of why we have compliance requirements is so that we make better daily decisions, and that can matter across a variety of platforms. So when I talk about compliance in my work, I'm generally talking about compliance with three things. So the first is probably what we all as lawyers think about, legal and regulatory requirements. The second is industry standards. If you read the organizational sentencing guidelines, that is something that's in there. They don't say standards, they say industry practice, but you have to comply with legal and regulatory requirements. You also want to be in compliance with what your peers are doing, okay? And then the third thing is internal norms and expectations, okay? So you could end up with a problem, even a firm could end up with a problem, even if you have not violated the law. So the best example of this that I can come up with is after the 2008 financial crisis, a lot of banks got in trouble for how they processed foreclosures, home foreclosures. It wasn't because what they did was unlawful, it was because what they did was not in accordance with what they told their customers they were going to do. So they violated their internal policies and procedures in engaging in the foreclosure process, and that resulted in a range of very large settlements with the OCC and the Fed, and then a significant remediation effort after to provide some sort of monetary compensation to folks who were improperly foreclosed upon. But that had nothing to do with a violation of law, right? So when I think about it, I think about legal and regulatory requirements, industry standards, and internal norms and expectations. And the goal is to make sure that these are actually being done in a meaningful way, not just a check the box on paper way. Okay, so I've been working on a compliance project for a really long time. Indeed, before Abigail was born. I'll be honest with you, I did not come up with the idea of this project. So way back in the day, when I was a baby law professor, I went and I presented this paper, Coordinating Compliance Incentives, at a conference. And I had this it was actually at Duke. I was not working at Duke at the time. And the Lawrence Baxter, who was a professor at Duke at the time, he said, you know, this is a great project. And you know what? You don't have one paper, you have four. And he sketched out 4 papers I could write. Now, what I ended up writing was not those 4 papers, I'm sure. But the intervention of someone senior saying, you don't have one paper, you have an agenda here, was just really helpful and powerful. Also, it was really good to put in my different annual reviews as I was going along. So the first project, which was started before Abigail was born, Coordinating Compliance Incentives, argues that compliance programs would benefit from regulatory and enforcement mechanisms that recognize when an institution is engaged in recidivist behavior across diverse regulatory areas and aggressively sanction institutions that are repeat offenders. And what I did in that project is I made it's a very small data set, but what I was concerned about, as I was reading the news, my compliance news, I realized that I felt like I kept seeing the same names over and over. Like the same company names over and over. And it turned out it wasn't a feeling, it was a fact. I sent an RA, I was like, why do I feel like I keep seeing this name over and over and over? And it ended up being true, but they weren't being treated as recidivists. So then I went and did this little project, and what I found was if you were a company that were before the same regulator or the same enforcement authority, you got treated like a recidivist. But if you were not before the same enforcement authority, you did not get treated as a recidivist. So you didn't get extra kind of penalties. And so the example, and that's true even if the underlying misconduct was the same. So in the paper, I talk about HP, which had 3 offenses within a 5-year period dealing with bribery. but they were under different statutory schemes, and so they were not treated as a recidivist. Now, this makes sense because when you think about how, like, so for example, the Department of Justice is made up, I work at DOJ antitrust, or I work at DOJ fraud. I don't, I care about this piece of law. I don't care about the law generally. And so if I work at DOJ antitrust, I'm going to care about repeat antitrust offenses. I'm not necessarily going to care about, oh, you violated X and Y and Z. This paper was eventually vindicated in one of the Monaco memos. So she was the associate, I'm not going to say her name. Anyway, she was a senior in the Justice Department under the Biden administration. And she put out, in one of her memos, she said, she instructed prosecutors to take into account other resolutions, even if it wasn't in that particular area. And I'm like the only person who would notice. I do have one friend who noticed. He's like, "You're happy today." I was like, "I am, but I'm the only, but only you know." But that was the base of the intervention, was like we should be paying attention to different types of resolutions because otherwise you don't have the appropriate external incentive. And when we get to the purpose-driven compliance, the external incentive really matters for people to set the floor. But if you aren't creating the external incentives appropriately, you're missing some opportunities. So project 2 is called the compliance process. So this was published in 2019. By then I had 2 children. And argues that utilizing a process frame, in particular prevention, detection, investigation, and remediation, to conduct root cause analyses in the aftermath of compliance failures will lead to the creation and implementation of better evaluation of compliance programs. So this is in a circle on purpose. So when you think about, I'm sure y'all have heard about gatekeepers, so people who help prevent misconduct. So the classic gatekeeper would be an internal, like an audit, right? Like, so you go get a big 4 accounting firm to come and do, an audit. You need prevention things, you need things in place to prevent misconduct, so internal controls, things of that nature. Those things also tend to be things that you want in place so that you can detect when there's a problem, right? Because you're not going to catch all of it. You're not going to stop all of it. So you want to, the things that get through, you want to be able to detect it appropriately. And then detection folds into investigation. A lot of people collapse the ideas of detection and investigation. I think it's important to keep them analytically distinct. I'll say more on that in a second. And then investigation, let's say I do an investigation and find that something went wrong. And sometimes everything's fine, so you don't need to remediate anything. But if something goes wrong, you need to remediate. But then you have to think about remediation as it relates to prevention. So we could have what I'm going to call thin remediation. So thin remediation would be when we think about the independent foreclosure crisis, and would be, oh, I improperly foreclosed on a homeowner, let me give them $1,000, right? So I've done a remediation, I've given them something back. A thick remediation would say, okay, why did I do that? What was wrong with my systems that resulted in me not following my policies appropriately? And what do I need to do to tweak my prevention efforts so that we don't do that again, right? And when you have thin remediation, you have additional problems. So in this paper, I use Baylor and actually Title IX as an example of an organization that failed at all 4 steps. But now we have some new news out regarding Binance. So Binance entered into a resolution with the government to resolve concerns, well, we can go back to money laundering problems. But anyway, so they resolved some stuff in 2023. And so in theory, they should have fixed their prevention efforts, right? So they entered into a resolution. They had an external monitor in place they actually had 2 to make sure that they were going to have appropriate internal controls and compliance systems going forward. And in the last couple weeks, we've had reporting in the Wall Street Journal and the New York Times that alleges that Binance had employees who were alerting them to improper payments being made. There were and allowing users who should not have had access to the system to have access to the system because of sanctions controls. And that instead of acting on that, the allegation is that Binance fired those employees. As I said, the resolution was from 2023, so not that long ago. And that suggests, so that might be an example. You see I'm being very careful, alleged and maybe and all these things. But that might be an example of a failure at all four, right? They didn't prevent the misconduct. It appears they didn't detect it originally. They did an investigation of some sort at the time. They entered into a resolution, which should have meant that they've remediated, right? Like that's the point of external monitoring, is to remediate. And now, about 2.5 years later, there are strong allegations that maybe that remediation didn't work. Right? Okay. So that's basically the 4 steps of the compliance process. And then the next paper, Complex Compliance Investigations, was published in 2020. That is the year that Samuel was born. And this paper is really focused on the step between detection and investigation. So something else that I was observing over time was it seemed as if a lot of companies were detecting potential misconduct and then failing to appreciate that what they had detected was an actual red flag, like so actually something meaningful that they needed to take more actions and steps on, and so they didn't do anything. And then the result was that the misconduct kind of festered, and the problems festered and stewed and got bigger, right? And so the 2 examples I use in the paper are Wells Fargo and General Motors. So the Wells Fargo fraudulent account scandal and the General Motors ignition switch scandal. And I use those 2 because one had a centralized model, organizational structure model, and one had a decentralized organizational structure model. And so I was comparing them to say that regardless of the model you have, we have these examples where there was formal detection, and there are after-action reports for both of these that were given to the board of directors that are public that you can pull. And so the folks within the firm knew that something was going on, but they failed to take enough actions to understand it properly. And so in the paper, I argue that to combat information silos within complex organizations, firms should adopt process-based reforms, like things like aggregation, principles of aggregation, that will bolster the firm's investigation into complex compliance failures. So in Wells Fargo, there were allegations that there were whistleblowers that were saying, hey, there's something weird going on with these accounts, and that they were investigated and then closed and deemed not actually substantiated. If you were aggregating the complaints, if you were saying, oh, I got 50 complaints about this thing, and we determined that none of those 50 were actionable, you have a lot of smoke. So that doesn't necessarily mean you have fire, but you do have a lot of smoke. And if you see a lot of smoke, you should be like, maybe I should go figure out why I have smoke. Now, it might be I have a fire, I have a real problem. It also might mean that I need to do some more education, right? Like people think there's something wrong. I need to educate them for them to understand why that thing that they think is wrong isn't actually wrong. But either way, the smoke is indicative of their additional action should be taken, right? For General Motors, they had these cross-functional teams that were supposed to combat information silos, but within those teams, it wasn't clear who was supposed to be responsible for the things that they detected. So while the teams were detecting things, then it went nowhere. So that was the 3rd paper, and then you're going to see a long hiatus. Maybe that's because I was working on other things. Maybe that's because during COVID I had a 4-3 infant and no childcare. I don't know. One of those things might be the true. Okay, so these were the first 3 projects, and then we get to the 4th project in the series. It's at the end. Purpose-driven compliance. This project is also what we would call in academia a problem paper. Like you just can't get it right, and it takes a really long time to figure out how to say the thing you want to say in a way that makes sense. And then you keep being like frustrated and then putting it back in your draft folder and then moving on to something else. Anyway, I finally, I think, got it right, hopefully. Well, even if I didn't, it's coming out soon. So, okay, so this is purpose-driven compliance. But to understand why compliance looks the way it does today, we need to understand how we got here. And part of where I ultimately ended up was, the compliance that we have today basically starts, actually, let me do the next slide first. So the foundations of the compliance program we have today really start in the 90s. So you have all these interventions in the 90s that then serve as, I think, what are the foundations for modern day compliance efforts. So in the mid-90s, we have some law and economics scholarship that comes out by Arlen and Crackman that essentially says if you want corporations to self-police, so in other words, if you want corporations to detect misconduct by their members, their employees, you can't use strict liability when they've detected things. You can't just say, oh, you found it, now I'm going to fine you $1,000. You have to have a mechanism in place for them to get some sort of leniency, because otherwise they don't have an appropriate incentive to engage in the self-policing, okay? So I've simplified a very complex law and economics piece of scholarship in like 2 sentences, but that's basically what the thrust of the argument. Then at the same time, around the same time, we have Caremark come out. So Caremark is the classic Delaware case, and it says that boards need to have information systems in place. Now, I personally am not a big fan of Caremark because it says you have to have an information system in place. It doesn't say you have to have an effective information system in place. And so I worry that Caremark doesn't incentivize effective compliance. I worry it incentivizes paper compliance. I have more thoughts on that, but that also happens, right? So now they need to have but you need to have an information system in place to defend against claims. And if you don't have one, that's a problem. And then we also in the 90s, I'm not going in timeline order for those of you who know exactly the years. We also get the organizational sentencing guidelines, which are very similar in their approach to the Arlen and Crackman scholarship, in the sense that they say you need to have an effective ethics and compliance program. That will prevent and detect misconduct. So basically every compliance program manual you see will use those 2 words, prevent and detect. And if you do, you're gonna get leniency credit, right? You're not gonna get as big a sanction. And then the other thing we got in the 90s was the Holder Memorandum. And so now this is the last thing that comes out in 1999. So this is when Eric Holder is senior at the Justice Department. So he puts out this memo. And as many of the Justice Department memos go, it starts all big, bold, and bluster. We are going to have more significant corporate enforcement. And it sounds like a dire thing's about to happen to the corporations. And then if you keep reading, you find something that's like more different. And so then he's like, but if you have an effective ethics and compliance program, we will know that you don't have to get as big a sanction, right? And so a lot of the memos read like that. Yates' memo on individual liability reads like that. So they start with like, we're really gonna hammer the corporations, but then they note that if we hammer too hard, then they're not actually gonna try and find the misconduct, and the government does not have the capacity to find all of this misconduct. We do not have enough attorneys. We have not distributed our public resources in that way, and so we are relying on the firms to try and police the corporations to police themselves. All of those things happened in the 90s. And then around 2003, 2004, we started seeing significant corporate enforcement activity out of the Justice Department. Now, you can imagine that there's a lag, there's gonna be a time lag between Holder announcing his memo in 1999 and the Justice Department both building capacity and like pulling the cases through before we start seeing pronouncements. So this is an area that's really hard to do certain types of empirical work, not hard, I think basically impossible, because we don't know when investigations start. We just know when the resolution is announced, right? And so that it makes it hard to do certain types of empirical work in the space. But we start seeing really significant enforcement activity in the mid-2000s. They're using what's called a negotiated settlement agreement, so a deferred or non-prosecution agreement, which I'm of the view that these are civil settlement agreements, so these are basically contracts. If you're a criminal law, my criminal law friends like me to be real precise there. It's a civil settlement agreement. It is not a criminal agreement. And we start seeing things like monitors, which are third parties who oversee remediation efforts for a period of time. We also see an increased market for compliance services. So you can imagine a world where a large law firm might read the Holder memo and realize, this is gonna be a wonderful business opportunity for me. And so it's not just what the government was doing, it's the opportunity the government created for the large law firms to sell certain types of business, right? And when they send out that client alerts can be a great source of information. I love reading client alerts. But they're marketing, right? Like they're attorney marketing. They're like saying, I have this expertise. And sometimes they're scary. They're like, oh, you should really have really strong Foreign Corrupt Practices Act compliance because look at all of these settlements that are coming out. So anyway, so it's important to remember that the market for compliance services also contributed to the compliance programs we have today. But all that happens in 2003, 2004. It's 20 years later. And there are certain assumptions baked into the scholarship and all of these enforcement activities, the stuff that comes out of the Justice Department. And so when I was working on this project, what I was trying to do, I did not succeed on the thing I was trying to do, let's just be clear. What I was trying to do was to push on some of those assumptions. And one of the assumptions I was concerned about was the idea that imperfect compliance is okay, right? So I presented this paper a while ago, and at the time I called it perfect compliance. And somebody senior from the Justice Department heard that name and was like, oh, I hate that idea. And I was like, oh, well, wonderful. Okay, so we ended up, but I do think that there are a lot of firms that ended up with what I'm going to call enforcement-driven compliance. So you see all of this significant federal enforcement activity, you see the Holder memo, you see the organizational sentencing guidelines, you see the client alerts telling you have to have this effective compliance program for you to get leniency, for you get the NPA, the DPA, and there's other things in here that I haven't mentioned. And so you end up with this enforcement-driven compliance, and sometimes there could be some problems with that. So one problem might be that because at the time in from 2003 to 2010, there was so much enforcement activity surrounding the Foreign Corrupt Practices Act, which basically says don't bribe foreign officials, that all the companies wanted strong FCPA policies. There's nothing wrong with having a strong FCPA policy, but it's not clear to me that all of those companies had that particular risk. Right, so you want to invest compliance dollars in a thing that is a risk for you, and just because it's an enforcement priority for the government doesn't mean it's an actual risk for the firm. And so we end up with this regime, at least in some instances, where the enforcement priorities are driving activity, but the enforcement priorities might not be equal to that firm's specific risk. And the other thing is that as we're building the capacity for sophisticated compliance programs, we spent a lot of time counting inputs to show the Department of Justice, look at all this work we've done. We deserve leniency. We deserve the NPA or DPA not to have to enter into a guilty plea. Okay. Most of the things they were counting were what I'm going to call compliance inputs, not compliance outputs. So just because I've trained 1,000 people doesn't mean that training did any good. Right? So counting how many trainings I've done, I'm counting an input. But if I wanted to know if it worked, I wouldn't count how many trainings I've done. I would do something else to assess the effectiveness of that training. And so for a time, I do think the Department of Justice was rewarding inputs and not necessarily focused on outputs. Now, they put out a memo in, I think, fall of 2024 where they have expressly said we're going to care more about outputs now. And that kind of makes sense if you think that you had to give organizations a chance to develop their compliance frameworks, right? So let's say we didn't have a lot of frameworks, now we have more frameworks, we have better sophistication, and now we might raise our standards of what we expect going forward. Okay, so as I said, my concern was the thing that was bugging me, the thing that was motivating this particular project was this idea of imperfect compliance, and that I also read some things in management literature, and the idea that small tolerated violations can normalize misconduct. Now, my law school friends immediately think I'm talking about broken windows theory, and I'm not. I'm talking about a behavioral ethics literature that is different than broken windows theory, that says that if we tolerate small amounts of misconduct, we're going to end up with more misconduct. And so I'm going to give you an example from the Wells Fargo report of why thinking small amounts of misconduct isn't a big deal can result in you not appropriately responding to a red flag, okay? So this is real text from the report, but I'll go to the smaller box. It says, the failure to frame the fraudulent accounts issue properly extended to senior management's view that firing 1% of the community bank workforce every year for sales integrity violations was acceptable. For example, in November 2013, blah, 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 John Stumpf was the then CEO, asked for data on the number of terminations associated with sales integrity violations. When the data showed that 1% of employees had been terminated for such violations, the CEO, the head of the community bank, and other community bank leaders received the figure positively, believing it proved that a vast majority of individuals were behaving appropriately. Okay? The red flag in that case, the flag, they didn't realize it was red. The flag went all the way up to the board of directors, and they were like, 1%, we're cool, and then they went on about their business. When in truth, it wasn't just the fraudulent accounts. Like if you go back and you look at Wells Fargo from 2016 through the current CEO, let's say a year into the current CEO, you find problems with auto loans, VA loans, there were all sorts of problems. They were so bad that at some point the Federal Reserve got so upset with them that they said, you have to stop engaging in certain business transactions. We're gonna force some people off your board. Like the Fed got big mad, okay? Because it was so many different things. But it's because they did not properly investigate a flag that they had detected. And in part, they didn't investigate it because they thought, well, we're not supposed to have perfect compliance, so 1% is fine. The problem I had with that, what was irking me is, but it's 1% of what? You're a bank and it's fraud. Like you're a bank and your employees, you know that your employees are engaged in fraud. That seems very much tied to the business purpose of the bank, right? Do you want a bank at a bank that's engaged in fraud? I don't think most of us want to, right? And so it's not just the percent. You have to think about, well, what does this mean? And what questions should I be asking? And so sometimes when we think about, oh, well, we're not supposed to have perfect compliance anyway, what does that mean for our further decision making? So that's all I really wanted to say in the piece. I just wanted to have this like thought experiment, and like, anyway, that didn't work. No one liked it. Okay, so it's part of that like 6-year lag there. Okay, so enforcement-driven compliance. I want to be clear. Enforcement-driven compliance was a necessary foundation for compliance to become what it is today. But it is not sufficient. So it is absolutely necessary. We have to have external incentives for firms to engage in appropriate conduct. I'm not naive. But it is not sufficient to ensure long-term sustainable and resilient compliance programs for tomorrow. And so then what should we do instead? So my paper, Purpose-Driven Compliance, argues that organizations should move toward purpose-driven compliance programs, which are compliance programs that are directed by the firm's purpose. So what is my business purpose? Like, so for example, for a university, what is the university's business purpose? I think the university's business purpose is something like to teach wonderful students and pursue rigorous research, right? So the university's business purpose is not going to be the same as the bank's business purpose, and it's not going to be the same as the car manufacturer's business purpose. But I need to know what my business purpose is, the inherent risks based on the activities necessary to achieve that purpose. The risks are not going to be the same for all firms. And then what are the ethical values and goals of that organization? Now, people get really uncomfortable when you start talking about ethics within complex organizations, and they say, well, what if what I think is ethical isn't what you think is ethical? I am not talking about our own individual ethics. But the firm itself, the organization itself, should have some sort of values and standards that it thinks are important. And it is, I think, perfectly okay for the firm to explain what those values are to its workforce and to expect the workforce to live up to those values, right? So that's what I mean by the firm's ethical values and goals. I don't mean it in like well, I think, this is immoral, but she doesn't, and so we'll just have to agree to disagree. It's not that. It's more like, what does the business want its standard setting to be? And so in a purpose-driven compliance framework, enforcement standards become a floor, not a ceiling. So you absolutely it's not that enforcement standards don't matter, like they do matter, right? Like you have to, that's a risk, right? Like that's part of your risk framework. So the core elements of a purpose-driven compliance program would be risk assessments grounded in how the firm actually operates. So not just what the enforcement realities are, but how the firm actually operates. They should be more proactive rather than reactive in design. In the early days of the Trump administration, he put out an executive order pausing Foreign Corrupt Practices Act enforcement. And then, the compliance LinkedIn, which is very nerdy, the compliance LinkedIn was all like a tizzy, like, oh, do we not care about the FCPA anymore? Well, if your program is tied to your actual risks, that should be dictating whether or not you care, not whether or not there's a pause from the federal government. Right? Because also the law is still on the books. The statute of limitations is more longer than the Trump administration. Anyway, so you got to think about what was my risk? So be proactive rather than reactive in design. Integration of ethics into the compliance infrastructure. So what are my values in addition to what the law says? And then attention to organizational behavior, not just formal structure. And so you would need to do some assessments on, does my compliance program work? Do people understand, like, so when I do these trainings, do people understand the trainings? Like, are the trainings sticky? Like, so, like, if I do the training today, do people remember the thing they're supposed to do in 6 months? And so things of that nature. Now, a purpose-driven compliance program will not sustain itself. It has to be supported in some way, structurally, culturally, and institutionally. So I'm going to talk about a few ways you could support such a program. So first, we would think about what board-level risk evaluations might look like. So you see this little chart, this little matrix. So this is how this or similar dashboards are created that tell us, oh, these are the risks a firm has, and green means it's a low risk, and red means it's a high risk. And in theory, no, not in theory, the board is supposed to help management set the risk tolerance of the firm. I can't set the risk tolerance if I don't know what the risks are, right? And so when I'm talking about you need to engage, like firms need to engage in a risk assessment based off of their business purpose, they have to really think about not just what the enforcement authorities are doing, but like, let me think about my risks expansively, because I can have reputational risk, I can have US enforcement risk, I could have EU enforcement risk, like there's all sorts of different risks that I should be taking into account. And part of that is, the reality is that boards of directors don't have that much time, and so they sometimes use compliance consultants to help them with that, and to think meaningfully about how you are engaging those consultants and what standards you might want in place when you're asking somebody external to do certain things. Another thing to think about is the mood in the middle. So everybody has basically heard of tone at the top. Not everybody's used the word mood in the middle. The corporate law scholarship tells us that the size of public firms has increased, so like publicly traded firms, has increased dramatically over the last 20, 25 years. So when Arlen and Crackman wrote their law and economics scholarship in the mid-90s, the size of corporations was meaningfully smaller than it is today, okay? And what that means is that when corporate law scholarship really focuses on the board of directors and the CEO, like the C-suite, there's a lot of distance now, a lot more distance now than there was 30 years ago between those top leaders and the folks who are lower level, which means that middle managers end up being the top of the organization for a lot of folks, right? So y'all probably don't think the top of your organization is the president of University of Maryland, right? The top of your organization is sitting right here, right? And so, right, so like, and all sorts of organizations are like that. But we as scholars have tended not to focus a lot on the folks in the middle, and that is, I think, problematic. Okay, so you got to think about the middle. You have to think about, I have a paper that I've been working on this, and there's a bunch of empirical studies that suggest, not that I've done, but that I found, that suggest that a lot of misconduct happens in the middle of the organization, and sometimes because you have somebody in the middle who gets a message from the top, and then they twist it around, and then deliver a slightly different message down below, and then you end up with a lot of misconduct and problems. So anyways, you gotta care about the moon in the middle. And then I'm working on a qualitative empirical project with Kevin Davis at NYU, and we interviewed a bunch of folks who did things in the compliance space. And this is the sort, because it's not correct to call compliance nascent today, but it was nascent not that long ago. There weren't classes on it in law schools. Like certainly when I went to law school, there wasn't like a compliance class. And so it's a space where being able to collaborate with others is really important. And sometimes people get nervous about collaborating with others because of antitrust laws. And so leveraging networks and collaboration is super important, and in theory should be incentivized in some ways, not violating antitrust, but to allow folks to figure out what are the real best practices as we move from looking at inputs and really focusing on compliance program effectiveness. And then, as is what we all talk about all day, carefully deploying emerging technologies. One of the recent DOJ memos has said when the prosecutors evaluate the effectiveness of the ethics and compliance program, they're going to look at how corporations use things like, well, the memo says data analytics. The next version is going to say something about generative AI. right? And so they're worried. So you have to think about how are we going to deploy these emerging technologies. And one of the headlines there is if you're using data analytics for like your sales or your marketing and you're not using it for your compliance, that's going to be problematic, right? If you've shown the capacity to use these technologies in one space in the firm, but you're not pulling it over to compliance, in theory, they're not going to be happy. And then I think it's really important to center ethics and culture. So we as lawyers tend to really focus on the legal and regulatory requirements, but the literature says the culture is much more important. Now, it's not generally in the law literature, but the management literature, the accounting literature suggests that culture is much more important. We don't stress it as much because ethics is harder to measure, right? Like, how do I go into the DOJ and try and get leniency and be like, we have such an ethical, like, how do I measure that? But it is not impossible to measure. There are a variety of tools that can be that are being used today, like climate survey. They call them, they use different words. So they might call it an ethical audit, a climate survey. There's lots of ways in which you can identify and you can measure things like psychological safety, likelihood to speak up if there's a problem. There are ways to do that, but you maybe shouldn't hire the lawyers to do all of that. Maybe you should hire someone else. So those are 5 things you might think about putting in place to shore up a purpose-driven compliance program. Sorry. I'm working on a paper with Ji Young Min on this. I didn't invoke her name, and I should because I did not write that by myself. Okay, so compliance is not merely a system for avoiding penalties. It is a commitment to protecting dignity, enabling human flourishing, and sustaining trust in the institutions that shape our lives. If these things go awry, bad things often happen. And if we have effective compliance programs in place, we can hopefully stop some of these bad things from happening, particularly at an earlier stage. And so the goal with the project is to kind of reframe from the enforcement-driven to really thinking about the business's purpose, risks, and ethical standards. And I have really enjoyed giving you this little overview, and I look forward to your questions. Yep.
All right, I'll kick it off while students are cooking up dozens of questions. So it was so nice to hear the arc of your work as well, but I think you lay out a beautiful blueprint of how to sustain a purpose-driven compliance program at the firm entity level. When we look inside the firm, are the incentive structure of the current board members as individuals aligned with actually doing the work to sustain this? Because we have fiduciary obligations, some might say at the corporate law level, to maximize profits for shareholders. Capital markets are putting immense pressure to maximize stock price. We have directors who care a lot about their reputation, getting another board seat, at the same time facing some individual risk of liability on their care mark. So how do all of those personal incentive structures of the board members align or not align with the vision that you lay out at the entity level?
So I think probably not in a sufficient way right now when I think about the board of directors, because I do think that we've had, like I said, when I think about Caremark, I've often thought all that does is incentivize a paper compliance program. It doesn't actually incentivize effectiveness. Although in the last maybe year and a half, I had reread a piece by Kim Krawak called, I'm not going to remember the full title, but it's the cosmetic compliance piece. And when you read it, it's not actually about paper compliance programs. When you read it, it's about something different. And one of the things, and this is an article I think it's from a long time ago. And one of the things she says in it that is absolutely true. Okay, so when we evaluate whether or not a board of directors has done what they're supposed to do, what we should be thinking about is what this board did ordinary and customary? Okay, so is this an ordinary and customary thing for them to have done? But ordinary and customary is not just established by Delaware. The work that's being done federally changes what is ordinary and customary. Because if I'm a public, at least for public firms, if I'm a public firm, I'm also incentivized by the federal enforcement realities, and I'm incentivized by industry standards and practices. Like, I don't want to fall behind my peers, because then I'm not doing what's ordinary and customary. And so Delaware might say one thing, but if we're really thinking about what's ordinary and customary, what has been going on federally has raised the bar on what counts as ordinary and customary, even if like the case law from Delaware hasn't caught up. I hope that makes sense, right? And so there should in theory be an interplay between what Delaware is saying and what's happening within corporations as a result of the federal enforcement efforts, because that federal enforcement effort is shifting ordinary and customary. So I don't think Delaware, I generally have not thought much of Delaware law in this space. And I'm pausing because obviously we've had a few cases with regards to mission critical risk. And that to me, I perked up. I was like, oh, interesting. Are we going to do something different? But I don't feel as if we have enough cases to know exactly what's going to happen. But if we think about ordinary and customary, the standards should be continually changing because the federal enforcement activity has changed over time, and the federal enforcement expectations are constantly changing, right? And that is really seen in the last DOJ, it's called the Evaluation of Corporate Compliance Programs, the ECCP, that came out.
Yeah, hi. I'm a practitioner, and the thing that's fascinating about what you're describing is that the new last year Trump administration has changed the goalposts on compliance and what it means to compliance and what actually the laws might be that you should comply with. Do you have any comments or updates on your paper on how you might perceive the new administration and its enforcement commitment?
Yeah, so I think that, so when the executive order came out that paused Foreign Corrupt Practices Act enforcement, I think a lot of, like I said, the compliance LinkedIn was all a tizzy and they were all concerned. They eventually undid that pause. They have shifted what they care about from an enforcement perspective, but they also put out a new memo that very plainly explained how to get a declination. So I didn't mention a declination in my talk. So a declination is, a firm has engaged in misconduct, but I'm able to persuade the Department of Justice that my program actually is really good, and you're just going to decline to prosecute. So I'm not getting a guilty plea, I'm not getting a non-prosecution agreement, I'm not getting a deferred prosecution agreement, I'm going to get a declination. And before this latest memo, whether or not you got a declination or any of these other things really seemed tied to just like the feelings of the prosecutor. There are a couple folks that tried to do empirical studies on this, and they weren't able to like tie your ability to get leniency to anything other than like the prosecutor's preferences. Under the new memo, it shouldn't be it really is a roadmap. Like you get a declination if you can show the following three things. And when I read that, I actually thought, this is, if I were a chief compliance officer, this is what I would take into my board of directors, because I would say, look, we know we're probably not going to have perfect compliance, but I also can show you under this memo, if I can establish the following three things, we get a declination. We're not going to get a fine, we're not going to get a monitor, we're not going to get all these other things. I'm just going to get a declination. So I actually think, to my surprise, to be honest, that memo is suggestive that folks should double down on their compliance efforts. Now, my general sense, my view, there are people who would disagree with me, my view is that in federal enforcement activity is just like federal regulatory activity. During Republican administrations, it goes down, and during Democratic administrations, it goes up. Like I said, I was saying before, it's hard to do the empirical work because I don't know when an investigation started, so I can't prove that, but I do think it's cyclical. And so the other thing I think that it's important for people who are advising firms to remember is, just because it's not a federal enforcement priority today doesn't mean it won't be a federal enforcement priority tomorrow, which is why I go back to the risk assessment. What is your corporate purpose? What is your business risk? And create a compliance program that is tied to those things. And even as the government goes like this with its enforcement priorities, if you've really tied your program to your risks, you should be pretty durable, even as the enforcement priorities are shifting.
Professor, thank you for speaking with us. With risk management and compliance, there's a tendency to try to be at the middle of the bell curve. Right? If you're left of the bell curve, you're not doing enough, so you get spanked with the highest fines. If you're to the right of the bell curve, you're spending more compliance than your competitors, and maybe it's too much. If you're the gray man in the middle, it's a nice sweet spot and you have plenty of company. The purpose-driven compliance sounds like it's maybe a bit right of the bell curve. How do you sell this to management?
That's a good, okay. So that's an excellent question. And I think you're right. I'm to the right of the bell curve. So I'm suggesting let's do something more than the floor. Let's do something higher. And you're right. You have to sell it to management because it's going to cost more money. So Matt Galvin, he's had a long compliance career. He was at the Justice Department. I had him come talk to a couple of my classes last year. Before he was at the Justice Department, he was the Chief Compliance Officer at AB InBev. And he was one of the first people, or at least the first well-known people, to really use data analytics in the compliance program. And so one of the questions I asked him was, how did you sell it to your board that you were going to put all these initiatives in place? And basically, he showed them how he was going to save them money. And so one of the things he did, so like Foreign Corrupt Practices Act, you're not supposed to bribe other folks. One of the things he did was he created a bounty. He said, if you tell me where bribes are going, I will give you 10% of the money you saved me. That allows him to identify his pain point. It allows him to cut off that pain point. It allows him to pay less money in bribes. But more importantly, he's lowering his enforcement risk because he's proactive, right? So he did all these like interesting things where he was able to show, I think you're right, that you have to show that this isn't just costing money. Part of it is an education of management of the downsides of the enforcement action down the way, and people don't always think about it. So like a few years ago, I was talking to a GC who was in the middle, was almost done with the monitorship. So you can just trust me that if you do an internal investigation and then you have a monitorship after the fact, that you've spent tens of millions of dollars, and they certainly had. And I told him that I'd had a dinner with somebody, a chief compliance officer at a different company, where they had hired 4 new people to do random audits worldwide, basically to mitigate FCPA risk. And I was like, what do you think about that idea? And he said, oh, well, that would cost so much money. I was like, you did not learn a thing. Because 4 people's salary is not nearly as much, like over the aggregate, over the long term, of internal offense, internal investigation, monitorship, right? This is someone who's not appropriately assessing short-term and long-term gains, right? But being able to educate somebody about, like, yes, this might cost me money in the short term, but like, look at all the money I'm gonna save in the long term. So that's important for the management. I think the bigger problem actually is not management, it's getting legal on board. Because legal knows that anytime I raise the floor, I've also raised my zone of liability. And legal is often a reflexive no. And so after Wells Fargo came out, I had a different large bank asked to meet with me, and I realized eventually that was their concern, that the compliance department, the compliance folks at this bank, the compliance department wanted to do more, and legal was telling them they couldn't. And they were trying to figure out how do we get past legal, right? So there's a lot of different constituencies you have to get past to be able to do something that's above the floor.
Well, I kind of feel bad for asking this question, but how do you get past legal at that point, right? Like, because what I can conjure in my mind could be an extreme level of different obstacles that can come from that higher standard that you articulated. What's your insight about how to get past legal at that juncture?
So I think it's really important to remember that legal risk is only one type of risk, and to make that case plainly to the board. I'll also say that over time, because that conversation was a while back, over time, there's been a push to give chief compliance officers a direct line of reporting to the audit committee, so not go through legal. And I think there's an emerging best practice, if it's not already in place, that the compliance officer would have time with the audit committee without legal there. And the idea there is to really make sure that you're understanding the risk appropriately. But but this is true of anything, right? Like, so anytime I as a leader want to make a change, I have to think about who are the different constituencies I need to be on board to make that change. It is unlikely that I'm going to be able to make the change all on my own. And so I have to think about what are the arguments that I need to put in place so that legal understands that, yes, it could increase our legal liability, but it might really help with our PR, or it might really help with our consumers, or it might, right? And so so when I think about a risk assessment, I do not just think about legal risks. There are a bunch of different types of risks that one should be taking into account when they're doing their risk assessment. And after you've done that appropriately, then you make your decisions, right? But for management, you have to show them how you're going to save the money and how it's going to add value to the firm. And for legal, you have to show them that the only risk is not the legal risk, and these other risks could be just as bad. Well, thank y'all so much. I've really enjoyed this.